mentioned cruise cases just for a few moments ago. Cruise cases are a little bit different, but they are cases that are controlled by maritime law.
Correct.
And so kind of tell us a little bit about some of the issues and pitfalls, because I think a lot of people right now, maybe over the summertime, have been on a lot of cruises, and I kind of get this question from time to time. I slipped and fell, I did this, I was on an excursion, this happened. What are some of the issues though with cruise cases that people need to be made aware of?
Well, similar to the question just a few minutes ago, we've seen incidents that have happened that have resulted in tragic injuries, but we've also had cruise accident cases where the pain wasn't discovered until maybe a couple of days later after they got home. And so the important thing is to make the report right away, because right then it puts the company on notice that they have to do something, which is find out what happened, get the videotape, take any pictures that are necessary to preserve the evidence so that when the time comes to have a trial or some sort of negotiation for insurance proceeds, the evidence is there so that you can make a case.
Yeah. One of the other pitfalls that I've run across in my practice is there's two things. Number one is a shortened statute of limitations, and we'll talk about what a statute of limitations is. And the other thing is a choice of venue that is in the cruise documents. Tell us about a little bit, both of those things. Let's define what a statute of limitations is, and then choice of venue and what that means.
Sure, absolutely. The statute of limitations is the legal period in which you have to file a lawsuit. Depends on the type of claim you have, depends on what state you're in and what law governs. And you should consult a lawyer before ever making a determination of how much time you have to sue. In addition to that, there can be a shortened time period that's in the cruise ticket contract, which is commonly about 6 months. So if you have a year to file suit under the law, arguably, the ticket might say, well, despite you having a year under the law, you really only have 6 months. So this is something you need to take heed of right away when you have a potential claim.
And now the choice of venue doctrine, or this also typically tucked away in the mice print of the cruise contract. What does that typically tell us that you've got to do too?
Well, it's going to tell you you're going to have to file a suit in the Southern District of Florida in Miami. It's where nine times out of 10, that's where we have to file a suit on these.
And if you have a cruise that goes out of Miami, I've seen the choice of venue doctrine be Los Angeles, California.
Absolutely.
And they do that so that it becomes burdensome on the person bringing the case.
Exactly.
You know, if you're taking a cruise out of Mobile or taking a cruise out of New Orleans, you know, typically you're from the Southeast, you know, when I call the general Southeast, you're not from Miami. The distance between Panama City, Florida and Miami is the same distance between Panama City and Cleveland, Ohio. Would you want to go file a case that's worth $5,000, $15,000, $25,000 in Cleveland, Ohio? It's the same thing about having to go to Miami. So the cruise lines do that on purpose, and they put those two things in there to make sure that, you know, small cases sometimes can't get prosecuted, but we also have folks like yourself that if the choice of venue is in New Orleans, we call you up and you're right on it, you can take care of it. We also have people down in Miami that if we need to, they can, you know, get right on it down there in Miami. And I've now learned some folks out in Los Angeles, California. So we eliminate that. We level the playing field for the folks that have been injured and do that. Our phone lines are still open, 850-392-1544. Or again, the email is open, lawcall@wmbb.com. Let's talk about something though. What's the difference between workers' comp and Jones Act? And if, you know, sometimes people say, well, I'm working on a ship, you know, is that the same thing or is it different? Are there different time periods, different reporting periods, just kind of go through that with me a little bit, Josh.
There are major differences between the two. Workers' compensation is usually land-based. It's for a worker that is a construction worker, for instance, who's working on a construction project and has an injury and wants to file a claim. Well, his remedies against his employer fall under what's called state workers' compensation law, meaning that you receive workers' compensation benefits and medical benefits in exchange for the waiver of your right to file suit against your employer. That doesn't mean you can't file suit against third parties that might be responsible in those instances, but vis-a-vis your employer, you're limited to state compensation remedies. The Jones Act is different. The Jones Act applies to offshore workers that work on ships. You have to be a member of a crew of a vessel in order to qualify as a seaman under the Jones Act. And what the Jones Act does, it preserves the right to file a claim in court against your employer for the standard lawsuit remedies. You have to prove negligence or unseaworthiness, you have to have medical causation, and then you have to show damages. And if you can, so you have a standard tort-based right against your employer under the Jones Act, whereas under the state law you don't, under state workers' compensation.
Okay. What about somebody that's working at a port, they're loading or unloading a ship? Is that a Jones Act issue or some other type of workers' comp?
That's a different, actually a different type of issue. That is called a Longshore and Harbor Workers' Compensation Act employee, and commonly known as a longshoreman, who has a workers' compensation remedy against his employer. So it's similar to state comp in that you don't have a right to file a lawsuit against the employer directly, but it's a federal act that preserves federal workers' compensation rights against the employer for those types of workers.